Erika Bachiochi is a legal scholar who works at the intersection of constitutional law, political theory, women's history, and Catholic social teaching. She is a fellow at the Ethics and Public Policy Center. She's also the editor-in-chief of Fair Disputations, the online journal of the Mercy Otis Warren Initiative for Women in Civic Life and Thought at the School for Civic and Economic Thought and Leadership at Arizona State University. She is a 2024-2025 fellow at the Nesty Center for Faith and Culture at the University of St. Thomas in Houston, where she's teaching a women's history course at the university's new Catholic Women and Gender Studies program. I did not know about this new program, so I'm glad that Erika keeps her biography always up to date. She is a 2018 visiting scholar at Harvard Law School. She was also a senior fellow at the Abigail Adams Institute nearby in Cambridge, Massachusetts, where she founded the Wollstonecraft Project. Her latest book, The Rights of Women, Reclaiming a Lost Vision, was published by Notre Dame University Press in 2021 and was named a finalist for the Intercollegiate Studies Institute's 2022 Conservative Book of the Year Award. Excellent book. Highly recommend you purchase a copy. It's now our pleasure to present to you Erika Bachiochi. Erika?
Thank you so much, Garrett and Trey and your wonderful organizations for hosting me today. It's really an honor to be with you. So I have some slides that I'm going to share right now. And then I'm going to get started. So today, I'm going to talk about what I take to be two rival accounts of the idea of women's rights in American history. These disparate accounts of women's rights map onto rival accounts of rights per se, which themselves map onto rival accounts of who we are as human beings. To my mind, the rival accounts of the human person and the theories of law and rights that flow from them explain much of our legal and political discord today. So whereas all American leaders might once have been working within a basically Judeo-Christian understanding of the human person and really within the natural law tradition, today's attorneys are much more apt to find themselves playing on a really different anthropological field altogether, one deeply inhospitable to what we might call the nature of things. Sometimes we're not altogether aware of the depth of this paradigm shift, and so we continue to employ common terms like rights without recognizing that the term itself conjures entirely different realities depending upon one's anthropological priors. Or worse still, some hospitable to the natural law tradition would seem to grant their adversaries erroneous account of a concept like rights or women's rights, only then to reject the concept outright. And I think this is a great mistake. So today I want to reintroduce the concept of rights as properly grounded in the natural law, and then turn to a natural law account of women's rights. It's my contention that the decades-long triumph of a distinctively early modern account of the rights of women has worked to really solidify what I take to be a deeply misguided understanding of what it is to be human, to be male and female. So I'll show how the natural law, or what I call the responsibilities account, works to correct the early modern, or what we might call autonomy account. But there's a complication, of course, in offering a natural law approach to the rights of women, which I'm going to have to contend with as well. For a good portion of American history, the laws of nature were understood to permit exclusion of women from participation in civil and political rights. And in some quarters of the political right, kind of online far right today, we're seeing these sorts of arguments rear their head once again. And so following women's rights advocates in the 18th and 19th century, I'm going to show why a natural law account properly includes the rights of women. I'll conclude by arguing that anti-discrimination law, properly understood, is a just determination, of the natural law in our day, and that, as properly understood, abortion restrictions do not discriminate against women. So let me delve into now these two rival accounts of rights in the American tradition. The natural law or responsibilities account that I'll champion and describe in some detail, and the regnant kind of autonomy-based early modern approach that I'll summarize here at the outset. Now, I'm painting with a very broad brush here, as there are fractures and complications within these two accounts as well. But for simplicity's sake, I'm going to kind of forge ahead with this bifurcated framework anyway. One note here at the outset, though, to complicate the picture just a bit, and you can be paying attention for this, is that I want to underscore that these two accounts are not perfect contraries. Rather, the responsibilities or natural law account affirms certain aspects of the autonomy account, like personal agency, for instance. It corrects others. And the natural law account generally offers a more fulsome and, I would say, realist approach to rights. Not legal realist, but actual realist in our lived bodies. And in this case, of women's rights too. So let's start with the autonomy account, the playing field on which much of rights theory operates today. It's more or less true that the autonomy account of rights finds its origins in the early modern state of nature theorists, especially John Locke, or really probably better to say a Hobbesian reading of Locke anyway, as well as a bit later John Stuart Mill. It's an account with which you are all very familiar with, those of you, probably all of you who are Americans, but I think it's really important to lay out anyway. So the early modern account generally views rights as protections for individual autonomy, or in Mill's telling, individuality. This account arises out of a view of the human person as one who is naturally self-sufficient and independent, who of his own free will, in Locke's telling, enters into civil society to protect himself and his property. That's going to be important. The individual at this level of kind of mythic abstraction is not by nature then a civic or political being necessarily dependent upon and in community with others. Even if Locke, as opposed to Hobbes, views the person as impelled by his natural sociality to enter into civil society, the mythic concept of kind of entering in the first place suggests an original self-sufficiency we see in all the early moderns. Indeed, Locke's abstract individual is defined as naturally and normatively self-owning, which means that no one should rule him, and I do mean him, without his consent. Further and importantly, man's quintessentially human reasoning power is, for all the moderns, a kind of calculating power employed to determine how one's desires and needs may be met, and fears of violent death for Hobbes or theft for Locke forestalled. So natural rights then in this account are those rights that exist before man enters into civil society. Thus, they flow from his self-ownership and individual autonomy. That word autonomy is etymologically a law unto oneself. And so these abstract rights are fundamentally liberties to make one's decisions autonomously with the low goal of self-preservation. So crucially, they're only secondarily concerned with duties, and then specifically duties to do no harm, which we obviously get from Mill, but we see in Locke as well. In this view, then, rights come first. Persons are most fundamentally bearers of rights. And then rights are in some opposition to law, the community, and the common good. And we see this very much in Hobbes. And all of this you can read with me in this course I'm giving this spring at the University of St. Thomas. If you're interested in that, just find me on at EPBC and email me, and I'll tell you more about it. So in the recent past, we tend to see this account of rights that I've been exploring kind of private property oriented on the legal and political right, and kind of self-expression oriented on the legal and political left, or Locke and Mill respectively. Obviously, things are changing with certain realignments taking place, but I do think we see the property-oriented account of autonomy rights, again, usually on the right, especially prevalent in abortion rights discourse, which I'm going to get to in a bit. Now, of course, it's indisputable that this early modern account, which I've just explained, influenced the American founders' understanding of the natural right to revolution and of just governance too. But it's really inaccurate to view this kind of mythical or abstract account of the human person as the whole picture at the American founding or thereafter. For at the founding and for much of American history, both small r republicanism and the Christian faith provided important communitarian counterbalances, and not only in the kind of religious practice of thick or robust Christian communities. These communitarian counterbalances could also be found at the state and local levels in the common law, the ever-present legal backdrop to the US Constitution, and the common law via private laws of torts, contracts, property, criminal law, and the like, everything you learned in the first year of law school, was deeply informed by the natural law, though you don't tend to learn that these days. But the underlying account of the person knit deeply in the natural law, and so the common and really civil law too in places like Louisiana, was distinct from that offered by the state of nature theorists. From Cicero and Aquinas to William Blackstone, the natural lawyer who, of course, most influenced the American lawyers at the founding and for a while there, human beings were not regarded as abstract, autonomous, or self-sufficient individuals. Rather, and this is really the first point of, sorry, I've just lost what I was looking at. So hold on a second while I find it. Okay. Okay. So the first point of distinction, as I try to change my slide and not get rid of my text, is that human beings are always and everywhere concretely embedded. Okay, we're on the right side of the screen here. Always and everywhere concretely embedded as members of mutually reinforcing societies upon which they are inescapably dependent and to which they are responsible. Because of the kind of being a human being is, each is born into and needs a family. And the family, which is, of course, essential, but itself incomplete, needs civic and religious, political, and political communities to properly develop according to its highest rational end. Indeed, in the natural law tradition, and this is my second key point of distinction, the gift of reason enables human beings not merely to calculate how their needs and desires might be met with a view to self-preservation and avoidance of harm, though of course practical rationality enables this. Again, they're not perfect contraries. Additionally and crucially, human reason is understood to participate in God's eternal reason. It naturally obligates persons to avoid evil and to do good. As Cicero put it, most famously perhaps, reason summons to duty by its commands and averts from wrongdoing by its prohibitions. So, contra the moderns, then, we are rational beings who have and can naturally discern and act in accordance with our duties to others. The practice of the virtues in this account enables us to do so, if always imperfectly. So we arrive then at two features, in my view, that most distinguish the natural law responsibilities account of rights from the early modern autonomy account: the recognition of the concrete reality of lived independence and regard for the human being's unique status among the animals as rational creatures capable of participating in God's reason, and so knowing and virtuously carrying out the obligations of this law. So we see this in two instances in kind of early American jurisprudence, though there are books that fill others. As Pennsylvania Judge Jacob Rush explained in 1796, the natural or moral law is that law which is founded upon the eternal reason and fitness of things, and enjoins those duties which, as dependent creatures, we owe to our Creator and to each other. Or, according to early American jurist James Kent, the universality of the sense of rule or obligation is pretty good evidence that it has a foundation in natural law. So natural obligations, by which I mean goods to be pursued, are at the very center of the natural law account. And so natural law summons, enjoins, and defines natural duties, the goods human beings ought to do and the harm that we ought to avoid. These natural duties then define the contours of natural rights, both of which are then specified variously as civil and legal rights and duties. So contra the early moderns, rights don't come first. Properly understood, they are intrinsically knit together with duties. Indeed, the pre-moderns had only one word for both: use, or the root of justice, or what one is owed. So understood in this way, both rights and duties are, in the words of John Fittis, twin ways of naming what is objectively just or right vis-a-vis other persons. And as such, they are always correlative. Natural duties, he helpfully explains, this is John Finnis, are the normative foundation of the virtue of justice. They provide the oughtness. One should love one's neighbor as oneself. Rights then are the ontological foundation. One is due just treatment because of the radically equal rational creature he or she is. So rights and duties, so viewed, never exist independently of another. And I develop all of this in kind of great detail in an article in the American Journal of Jurisprudence. So you can see this correlativity between rights and duties in two ways. So the first way, one properly has a right to carry out his or her duty. So here's some examples. I have a natural duty to worship my creator, so I have a natural right to worship. John Henry Newman put this great. Conscience has rights because it has duties. Or another example, I have a natural duty to preserve and provide for my family. So I have the natural right to procure the necessities of life via, say, a just wage. Or, and this was a very frequent one, as we'll see for the women's rights advocates, I have a natural duty to pursue the truth. So I have a natural right to learn. And then the second way that the rights and duties are correlative is that is a claim against one who owes natural or legal duties to the rights bearer. So for instance, parents have natural duties to educate and nurture their children. Children then have kind of a claim to that nurture and education from their parents, or you can imagine in loco parentis from other communities like educational institutions and if necessary, from the state. So, as determinations of the natural law, then legal and civil rights ought not be understood as kind of liberties for mere autonomy or abstract protections from others, even as, of course, personal liberty of conscience and action, as well as protection from evildoers, are crucial aspects. Positive rights rather should be guarded as correlatives of concrete duties owed to and by concrete others in specific situations, and is generally oriented by the civil authority to the common good. In a word, kind of to put this all together, freedom from arbitrary rule, which is so central kind of to the early modern mindset, but really present in the natural law account too, is freedom for excellence, for which the natural law account recognizes that we human beings are made. And my view of this is that the two are held together at the American founding and in the Reconstruction era too, as well as we will see in their early account of women's rights. So in this way, positive law and the rights and duties it enunciates may properly act in its educative or formative capacity. How? Well, by directing citizens to better understand their particular way, by virtuously carrying out their particular responsibilities in their particular sphere of action, may carry out the common good. Here's Finnis again. I really like this quote a lot. One acts appropriately for the common good. This is the second quote down, not by trying to estimate the needs of the common good kind of at large, but by fulfilling one's responsibilities to ascertained individuals. So that is to those who have particular rights correlative to one's duty. So the way I think of it is that the common good is best understood not in a Platonic kind of from above form, but in a more Aristotelian from below form. So in my experience, reorienting our thinking from speaking about rights to speaking about responsibilities is a very helpful way to shift out of this autonomy orientation that we're all sort of stuck in the world, and especially with contemporary law and politics with our interlocutors. After all, inquiries into rights properly demand that we first ask about natural and legal obligations. What injustice is owed by or to concrete and particular human beings in concrete and particular circumstances? So regarding abortion, an area I work in a lot, ask not about competing rights from which you can draw. When you do that, you're drawn into these kind of abstractions. And I'll talk about this more a bit, but instead, what is due the unborn child and his or her mother or father, since these dependencies and responsibilities are not isolated from one another, but are dramatically interwoven, especially in this case, and are really necessarily concrete. So as we move from this general account of rights to specify a natural law account of women's rights, I want to note that the natural law account includes two really important moves. One is stable or universal principles of human flourishing, coupled with, secondly, dynamic or situational determinations. So the first demands that all persons, including political leaders, are subject to a higher law that both judges and legitimates their actions. This is what we're claiming when we say something is unjust. The second demands on the ground prudential assessments of concrete circumstances that change as history unfolds with shifts and transitions in technology, political economy, philosophical or theological underpinnings, and really other causes of cultural and social change. And I think we need to hold these in really high tension, because if you decouple them, it means you're no longer reasoning within or in accord with the natural law. They need to be held together. Okay, so without foundation kind of set, let's move into two rival accounts of women's rights, which will hopefully put some flesh on what I've discussed. So the autonomy account of women's rights is the one with which we are really familiar, but I want to argue, as I do in this recent book of mine, that there's another more cogent and philosophically coherent account of women's rights, one discernible in the thought of the 18th century philosopher Mary Wollstonecraft and her American heirs in the mid-19th century. It's kind of a lost vision of women's rights grounded in natural principles that, as my subtitle reveals, I think we ought to work to reclaim, and which a lot of my work is attempting to do. So the autonomy account hardly needs an introduction. If you've read any constitutional law in the last 20 years, especially with regard to abortion rights, you see it right away. So individual autonomy is first grounded in due process liberty and then attempts at equal protection is really the operative principle at work in constitutional arguments for abortion rights at the federal and state level, which really abortion rights have themselves become kind of the sine qua non of women's rights in our day. You don't hear much about other ones. Well, anyway, indeed, the dissenting justices in Dobbs make this really apparent on the very first page of their opinion. Quote, respecting a woman as an autonomous being and granting her full equality means giving her substantial choice over this most personal and most consequential of life's decisions. As I've argued variously again in the American Journal of Jurisprudence, as well as a forthcoming article for the Texas Review of Law and Politics, where we talk about this as kind of 14th Amendment liberty as equal opportunity, as well as in a much shorter piece for the New York Times, the autonomy account of abortion rights draws from a quintessentially Lockean property rights framework. And you see this both in the Kansas Supreme Court decision in 2019 and in the Dobbs dissent kind of throughout. So a standoff kind of exists between the autonomous woman, we are told in the Dobbs dissent, owns her own body. We hear this all the time, obviously, in popular discourse too, up and against the nascent independent unborn human being who necessarily impinges on the physical autonomy of the pregnant woman, his or her mother. In this property rights account, the woman has a kind of absolute right to exclude another from her body as property, employing the use of force as necessary. So pro-lifers kind of respond to this that, wait, hey, the unborn human being has rights too. But when rights have long been misunderstood as a kind of autonomous self-ownership in the kind of legal and cultural imagination, I think it's very difficult, even for ordinary people, non-lawyers, to grant rights to the maximally dependent unborn child. Again, granting rights rather than kind of recognizing them. After all, the tiny, still developing human being is not, until viability at least, independent of her mother, and so would not seem in the Lockean property rights framework to kind of own herself. And I think this is why viability takes up so much kind of oxygen when we're talking about abortion rights, especially in the legal context over the last several decades. So in this autonomy-oriented framing, which we've seen in most of the state battles over abortion in the last 2 years, the woman's bodily or decisional autonomy bests the very life of the vulnerable unborn human being. But abortion rights, so conceived, are only cognizable as rights when viewed from within this now regnant paradigm of rights as liberties for autonomy and protections from others. But rights to elective abortion make little sense at all when rights are viewed classically as the correlatives of duties as defined by law. Indeed, baked into these autonomy-oriented property rights claims is an a priori moral and legal determination that the pregnant woman lacks responsibility to the human being growing inside her. Or better, there's really no inquiry into responsibility at all. It's clashing autonomy rights all the way down. Duties would seem to have nothing to do with it. And note here, and this is an important part of my work for decades now, there's kind of a deep, there is a deep male normativity in this autonomous body as property rights account. And not only because the state of nature theorists from whence it came conceived of rights as limited to unencumbered and duly autonomous male citizens. After all, when a woman is pregnant, she is not physically autonomous in the way the man who sired the child is, the biological father is. This is, of course, the great defining asymmetry between men and women. Women reproduce inside themselves and men outside, as Aristotle put it long ago. A man can choose then, with full physical autonomy from the child he has sired, whether to affirmatively enter into paternal care kind of consensually or contractually, or he can just autonomously walk away. But a pregnant woman, her body has already begun sustaining the life of the new human being before she is even aware. Note that the kind of symbolic resonance with the basic view of the pre-moderns that we are always already embedded in relations of dependency and care. After all, to approach the kind of autonomy of the child-abandoning man, a pregnant woman must engage in a life-destroying act. And without the autonomy to affirmatively enter into her maternal duty to care for the child, we are told that she is neither equal nor free, a very kind of Lockean Hobbesian understanding of this. But the earliest women's rights advocates in our country did not conceive of their rights this way at all. Like today's feminists, they argued for self-governance and personal agency. This is kind of basic to any strand of feminism. And so they pushed strongly for what they called voluntary motherhood, or the right to engage voluntarily in that act that might make one a mother, that is, sex. But unlike today's feminists, they recognized women to be mothers with all the responsibilities of motherhood, not just when their children were born, but when from the time they began developing in their mother's wombs. So I'm going to give you a whole host of examples here. As the most radical among them, you can also find more examples in my footnotes and in my text. And I'll tell you about another great book that you should get and read. As the most radical among these women's rights advocates, and she was really was the most radical. Victoria Woodhull wrote, once pregnant, women were directly charged with the care of embryonic life, and the rights of children begin while yet they remain the fetus. And as she wrote elsewhere, it is as much a murder to destroy life in its embryonic condition as it is to destroy it after the fully formed, developed form is attained, for it is the self-same life that is taken. Great pro-life argument there. And here too is popular author and OBGYN Alice Stockham, who wrote a book that was published widely, translated, I think, into 7 languages, that was kind of for the ordinary woman. She articulated not only the correlativity of rights and duties in the context of abortion that we've just heard from Woodhull that I've explained, but also underlying themes of interdependence and participatory reason by which we know what injustice is due. She says, by what false reasoning does she convince herself that another life, still more dependent upon her for its existence with equal rights and possibilities, has no claim upon her for protection? I mentioned, and I'll again recommend the excellent new book out of Encounter called Pity for Evil, which offers really the most granular detail and kind of going right into primary sources of any book to date of the country's earliest female doctors and their views on abortion. Like Dr. Stockham, who I just quoted, these women knew the advancing science of embryology, and they wanted to ensure that ordinary women understood biological realities too. So here's Dr. Anna Dunsmore up on the screen, quoted in a piece of reporting in the women's rights newspaper, The Revolution, on the talk she offered to women about fetal development, and explaining to the attendees that the unborn child's life began well before the mother became aware. Dr. Dunsmore said that few women, even among the educated and intelligent, realize that the embryo is imbued with a life element prior to the moment when its physical movements become conscious to her. She goes on, the matter was the one least understood, but one necessary to comprehend in order that the duties and responsibilities of maternity and child culture should be realized. I think it's really ironic, actually, that many pro-choice feminist legal scholars today insist that our law retains something like the common law's treatment of quickening as a significant demarcation of the legal status of the unborn child today. But such an approach rested upon scientifically rudimentary understanding of fetal development, one that had to rely upon women's subjective feeling to detect and track the progression of pregnancy. So our earliest female doctors worked to correct this outdated medical understanding, even as the 19th century women's rights advocates worked to correct the common law's outdated conception of, say, women in coverture. This is all to say that the 19th century women courageously advocated for their rights to education and entry into professions within marriage and in civil and eventually political life, so that they, alongside men, could fulfill their shared responsibilities to their families and the community at large. Rights were not understood to free one from obligations or protections from others, especially maternal and paternal duties of care, but as correlatives of and necessary for carrying out these duties. Here's Dr. Stockham's book Toxology again, well articulating the need for men and women to share virtuously in these asymmetrical duties. She says, when girls are given proper instruction upon the relation of the sexes and understand how to guard and govern themselves, when young men are taught that virtue has as high a meaning for one sex, that is their sex, the male sex, as another, that is the female sex, that the protective chivalry of which they boast does not imply that they shall force the woman to the defensive, and that the paternal interest in and responsibilities for a child are equal to the maternal, then the temptation to produce abortion will not exist. And this, friends, is still true today. Studies show that when fathers support mothers, abortion rates go way down. So we see that the natural law account of rights correlative with duties. We see it early on in the Declaration of Sentiments and Resolutions at Seneca Falls. We see Blackstone cited for the proposition that human laws do not bind if they run contrary to the natural law. Resolve that the equality of human rights results necessarily from the fact of the identity of the race and capabilities and responsibilities. We see at another women's rights convention in Albany a few years later, the same appeal for women as rational creatures to enjoy civil, political, and economic rights in order to fulfill their duties. I'll leave that quote up on the screen. The most pithy was leading advocate Lucy Stone. We are all getting to be women's rights advocates, or rather investigators of women's duties. And I should note that Heritage Foundation will be publishing a very long report of mine on these early conventions, exploring kind of the arguments in those early conventions. Okay, so the natural law account of women's rights can be discerned even earlier and more comprehensively in the work, in my view, of Mary Wollstonecraft, though she has been she had been really long and kind of lazily regarded as a kind of Enlightenment liberal who simply extended to women the French Revolution's appeals for the rights of men. Close scholarly readings of her work in the recent decades, probably the last 20 to 30 years, have revealed her to be much more deeply informed by the pre-modern and Christian traditions. As such, it seems to me that her work serves as a crucial corrective to early modern account, on which I've argued abortion rights claims are grounded these days. So a few words about Wollstonecraft now before I conclude with some thoughts about anti-discrimination law and abortion today. So the philosophical case Wollstonecraft made for women's rights in 1792 was particularly robust because it was based not upon liberal conceptions of autonomous man, kind of pre-political autonomous man. And I do mean man, as I've argued today's rights theories tend to be. Rather, Wollstonecraft grounded her appeal in the common human nature men and women share, a nature she understood to be ordered to wisdom and virtue, human excellences that took their bearing in her thought from the singular wisdom and goodness of God. Human beings are endowed with the ennobling capacity to reason. I'm going to put a bunch of, I'm going to go one by one through these quotes, to rise in excellence by the exercise of powers implanted for that purpose. The capacity to employ reason to govern our appetites and direct us to live according to what is most excellent in us is that which makes us distinct from the animals. She says, in what respect are we superior to the brute creation if intellect is not allowed to be the guide of passion? Brutes hope and fear, love and hate, but without a capacity to improve, a power of turning these passions to good or evil, they neither acquire virtue nor wisdom. Why? Because the Creator has not given them reason. She thus shared the ancient view of human excellence as kind of imitative of God, but sought with Christians to universalize that quest beyond the landed classes by recognizing the, quote, native dignity of all persons as rational creatures made in God's image. For Wollstonecraft, we are radically equal in our dependence upon and responsibility to God. Quote, third quote down there, who can make us reverence ourselves, she asks, but a reverence for that being of whom we are a faint image. Thus, the ultimate purpose of every human life is to use one's own reason to submit to the unerring reason of God, to conform oneself to the nature of things as God has benevolently designed them, and thus to unfold one's human faculties in order to better oneself and to be of service to others. goodness has but one eternal standard, God, and thus all his creatures, regardless of sex or social status, are responsible to that single standard. And this kind of single moral standard is really basic in all of early feminism. Quote, especially up and against the sexual double standard and things like that. Quote, the only foundation for morality appears to be the character of the supreme being, for to love God is the foundation of wisdom, goodness, and power, appears to be the only worship useful to a being who wishes to acquire either virtue or knowledge. Were God's goodness not sought as the eternal rule of right, that by which we should judge all other claims of right, expediency and power would be all that remains to guide human actions. Man's arbitrary claims of power, heeding not the higher authority of God, were the source of every oppression in Wollstonecraft's view. And here there's some agreement, right, with those early moderns. She makes an important advance here for women and other vulnerable groups, articulating an ancient truth that we would also see in the natural law, right? That we hear at Seneca Falls and from the Reverend King's jail cell as well. Were there no higher standard of truth or virtue, no eternal rule of right, how could one judge a law or action to be unjust? Without eternal right to govern human norms, persons would base their actions invariably on what is most useful, pleasing, or convenient to them, and the weak would fall prey to the strong. Next quote. For man and woman, truth, if I understand the meaning of the word, must be the same. Yet virtue becomes a relative idea, having no other foundation than utility. And of that utility, men pretend arbitrarily to judge, shaping it to their own convenience. So, because of human interdependence, the common good of persons, families, and societies could only be achieved where the virtuous fulfillment of each person's responsibilities to others of utmost priority. Quote, a truly benevolent legislator always endeavors to make it in the interest of each individual to be virtuous, and thus private virtue becoming the cement of public happiness. An orderly whole is consolidated by the tendency of all the parts toward a common center. Wollstonecraft well understood with natural lawyers that no person is self-sufficient. We are all integral and dignified parts of greater wholes on which we depend and to which we are responsible. She saw that persons need for their flourishing the give and take within families, where each is responsible for the others, just as families need for their proper flourishing the goods common to the broader society. From each person's nature as a rational, moral, social being sprang forth certain discernible duties, she thought. What are those duties that characterized human beings? First, duties to self, to develop one's rational faculties and to master one's appetites, to family, to care for one's dependent children, spouse, and elderly parents, to fellow creatures, to be useful in one's work and respect the human dignity of all others, regardless of social status, and to God, to pursue truth and goodness, and to trust in his providential designs. Though it sounds awfully foreign to our modern ears, Wollstonecraft would say that the being who discharges the duties of his station is independent. So the duty of the rational creature to seek the truth is really the principle that underlies her tolerance of religious pluralism and her sympathy for the dissenting sects in Britain in her time. Still, she did not view religion as all out of place in the encouragement of moral duties. Quote, the wisest laws would not be sufficient to restrain men within the bounds of morality without the powerful motives which religion affords to interest the affections and enlighten the understanding. And because she viewed the affectionate inculcation of virtue in children to be the most essential of all social duties, she regarded motherhood and fatherhood to be the very highest of all callings. So in her view, civil and political rights are not derived then from kind of theoretical ruminations about a mythical state of nature, but from actual moral duties to others. We are not first and foremost autonomous beings with rights, but rather men and women in concrete and particular relation to one another, with concrete and particular duties to one another. A good and just government enables and encourages the fulfillment of each person's concrete duties, in part through the protection of her rights. A person must be free, of course, to pursue the right course of action. Quote, I mean, therefore, to infer that society is not properly organized, which does not compel men and women to discharge their respective duties by making it the only way to acquire the countenance from their fellow creatures, which every human being wishes in some way to attain. So the political freedom she sought through Republican government and, yes, natural God-given rights was then at the service of the moral development of each person. which consisted in large measure of virtuously fulfilling the ordinary duties of life. As she said, a right always includes a duty, and the purpose of both was the virtuous development and thus happiness of persons and societies. As she wrote most famously, society can only be happy and free in proportion as it is virtuous. So by now, I hope I've shown that Wollstonecraft and the antebellum women's rights advocates who came after her in our own country grounded their rights claims on a natural law foundation rather than on spurious claims to autonomy. But I have one more argument to make, that despite the misguided appropriations of anti-discrimination law in our day, properly understood anti-discrimination law, kind of a basic understanding of anti-discrimination law, is a just determination of the natural law. So the most obvious point to note, and I'm going to have to kind of race through this stuff here, is one that I detail in a recent article in First Things. If you haven't read it, go check it out. The way in which anti-discrimination law in the 1970s serves to correct erroneous accounts of women as less rational than men, or especially bound to the private sphere because of women's distinctive capacity or biological function in childbearing. There was a time when natural lawyers followed Aristotle concerning kind of the want of female rationality or lack of authority of their reason, and so also argued that the natural law properly defined wholly distinctive responsibilities for men and women, public men and private women. But it's not only the natural law principles that had to be better applied to who women are in the fullness of their humanity. There's also an intervening historic change in circumstances to which the first women's rights advocates were responding, and so to which natural law principles need new application in our day. So it's not surprising then that those first sustained calls for women's rights, as we've seen, which I see as specifications of the natural law, occurred with the rise of liberalism and industrial capitalism. And I've written a whole bunch and spoken a whole bunch about this, and others like Mary Harrington and I think Nancy Pearcey and others have talked quite about this. So I suspect you are all quite familiar. But basically, the radical interdependence of subsistence living and kind of the agrarian household economy require this deep collaboration and reciprocity between men and women. It was the kind of very locus of, and the really origin of economics, right? Home economics, because of kind of the centrality of the home and the household in the civic and political order. But industrialization's sharp fissure between home and work brought about a transformation in the nature of women's work, and so paternal and maternal duties as well. So imagine remunerative work leaves the home, men leave the home, and wage-earning men then become newly dependent upon industrial capitalists, as they hadn't been before, of course, making caregiving women newly dependent upon wages, the wages of their husbands. And so all this in turn made married women far more vulnerable to kind of increasingly stressed husbands' potential exploits in new cities, bars, and brothels, and to male abandonment and bad behavior generally. Poor women, or those whose children's fathers had abandoned them, were themselves foisted into the harsh industrial workplace, leaving children to fend for themselves, of course, if they weren't themselves working. So women's legal subordination in marriage, which was virtually unchallenged during a time of kind of subsistence living within the household, kind of economic interdependence, exacerbated the difficulties facing women. And so the early movement for women's rights was a kind of a reaction. It's usually thought of kind of as an aspect of liberalism. It was also a reaction against liberalism, which cleaved home from work, economics from politics, public from private, man from woman, and too often parents from their children. So as I document in the recent book, and I give lots of chapters to all of this, the very first claims for women were, joint property ownership, to recognize their still immensely productive work in the household. And then, of course, just workplace laws and protections. There were internal debates about all that. And then finally, with the unsung work of the Women's Christian Temperance Union, kind of state by state, what Frances Willard called the home protection ballot, women's suffrage. So decades later, anti-discrimination law would account for both women's rational capacity. Whoops, skipped all those. Sorry, I guess I wasn't keeping up with my slides. Would account for both women's rational capacity as well as their distinctive duties of care. So it ruled in several cases in the early 1970s that women could not be excluded from employment opportunities on account of their sex. both with regard to Title VII, which put this in the Civil Rights Act, but then also the Equal Protection Clause and its interpretation. But employers could accommodate women's greater responsibility in childbearing. You can see kind of this tension in Nevada v. Hibbs. This careful balancing offered important relief to poor and working class mothers, especially like Ida Phillips, who was the first successful litigant in a Title VII case in 1971, whose income, due to her husband's alcoholism and neglect, was the only sure means of provision that she and her 7 children employed. So just like those early women's rights advocates, Philip justly demanded kind of particular rights to carry out her particular duties. So when a woman is pregnant, our law justly protects her from workplace discrimination as she seeks to carry out her duties to protect, nurture, and provide for her child. And in a post-industrial economy in which women are as educated as men and younger fathers, it seems, are increasingly invested and engage actively in the care and nurture and education of their children, determining who does what when with his or her particular gifts requires kind of a practical wisdom that mothers and fathers must employ for the good of their own family in kind of what I call family autonomy rather than individual autonomy. So legally constraining that family determination from without encourages employers to punish fathers who, for instance, request leave or other accommodations to provide their families with care rather than wages alone. Illicit sex stereotyping also presumes that mothers are less competent or committed to their professional work than are men or childless women, despite the fact that mothers often need income from their work in order to care for their children. So sex discrimination law, therefore, rightly distinguishes between policies that properly advance and protect the goods of the family and caregiving and of women in childbearing from those laws that arbitrarily discriminate against or denigrate or, in the words of VMI in 1996, artificially constrain women or men on account of their sex. But really importantly, and this is often lost in how we talk about anti-discrimination law, it does not prohibit discriminating between sexes. As such, abortion restrictions don't discriminate against women, contra many claims in the states right now. And this is what our forthcoming Tropel law review article is about. Instead, properly understood and articulated, a prohibition on elective abortion implicitly maintains that an expectant mother, like an expectant father, owes duties of care to unborn child, such that she cannot legally end the child's life. Okay, I'm going to skip ahead here. I think that we could understand this idea of sex discrimination if there was, a real health impact or medically necessary in some way, need to remove the child from the mom in a case of real severe health consequences. But that would be very different from kind of intentionally going after the child. So to conclude, law and culture have a much more difficult time enforcing these paternal duties to protect and nurture and provide for children. I think this is really the great challenge of our time, but we don't allow fathers to end the lives of their own children when paternal duties become too onerous or unchosen. We should work instead to ensure fulfillment of paternal duties to the fullest extent possible. In light of the foregoing, it seems to me this is what natural law requires today. I'm going to stop sharing my screen and apologize for going on too long and hopefully answer a couple of questions.
That was excellent. Erika, we have a queue in which we have some questions already, but I'll take moderator's privilege to ask the first one, but also remind all of our attendees that if you'd like to ask a question, please phrase it please phrase it in the form of a question, but also use the Q&A function on Zoom, and please list if you would like me to read your question or if you'd like to read your question yourself, and we can recognize you to do that. In your presentation, you talk about the anti-discrimination context, the employment law context. In what ways, though, does transgenderism present a unique challenge to the natural law framework of the rights of women, particularly now in a Bostock world that may not be as settled as as transgender activists might like it to be, but at least in the very immediate future, we are basically litigating with Bostock in the background.
Right. Yeah. Yeah. And I would say, I mean, my account is very much basic anti-discrimination law. There's a lot of, EEOC guidelines that I would very much disagree with because they sort of flatten the differences between the sexes entirely. So with regard to Bostock, which for our listeners is, a recent Supreme Court decision, which is interpreting Title VII to argue that the word sex, or not so much the word sex, but because of sex includes transgender status within employment contexts. And so I think the really important thing to note is that case really depended upon a binary, a sexual binary, a biological binary. So it's not to say, so Bostock does not, the account in Bostock, it does not give way to the account that transgender activists would like to see, which is that gender identity seen as something kind of in the mind takes over entirely for the distinction between the sexes. So the but for argument that Gorsuch made in Bostock is depending upon that biological, that reproductive binary. So that's good news, except the lower courts don't get that because transgender ideology is so complex and confusing that I think it probably hasn't been understood that way. The second thing to argue, just on the case of Bostock, is that the real danger of the way that was argued is there's something that the equation is between, even though there's a sense that men and women as kind of biological beings are different. And I'm going to read, I think I have here the language is that an employer illicitly discriminates on the basis of sex when it fires a person for traits or actions it would not have questioned in members of a different sex. And that traits and actions is really important because it's one thing to kind of put on a dress, put on makeup, even potentially do some kind of superficial cosmetic surgery or even, deeper kinds of surgery. But that's not, a trait or action. That's not actually similarly situated to an actual woman whose trait or actions might be something like having a child, right? Breastfeeding and the kinds of things that are actually discriminated against in the workplace, that employers discriminate actual women against in the workplace. And so kind of using the superficial understanding of trait and action is very dangerous to actual differences between men and women that need real protection. And so that's really my great concern. And I hope that, over the course of what has it been 2 or 3 years now, the Supreme Court and some of the people have come to, some of the justices may have seen kind of the nature it's wrong. There's a case up before the Supreme Court now that will do some looking at this kind of case again in a different context, and so hopefully we'll have some clarity about this. But I think the natural law case very much holds because of real differences between men and women.
Great, thank you, Erika. The next question will be from JWI founder and co-director Hadley Arcus. Daniel, could you turn on his microphone, please? Okay.
Is it on?
Yes. Go ahead.
Erika, that was quite marvelous. I'm with you on everything, but I just want to post a caution that what we're seeing with this notion of autonomy, as we've seen in our research, is really a modern heresy. And it really can't be imputed to Locke or even Mill, perhaps not even into Hobbes. Even Kant or Thomas Reid would not say that autonomy meant that you were the source of your own law. What autonomy meant from another angle, their angle, was that we are not governed by forces outside our control. As Thomas Reid says, we're dealing with people who have the active powers to cause their own acts to happen, to will or to forbear from acting. That becomes the mark of their condition as creatures fit for the rule of law and bearing responsibility. And so the understanding was anyone who was a moral agent, a person who could reason over matters of right and wrong, would realize, as Lincoln and Aquinas said, that he can't coherently claim a right to do a wrong. Even in control of my own body, I don't have a right to take the life of another human being without justification. I still have to explain why I'm justified in taking that life. But of course, in that old sense also, even with Locke, that you have a right, there are certain things you don't have a right to do even to yourself. Hence the notion of unalienable rights. Those we are not free to contract ourselves into slavery. We're not free to make a nothing of those things that distinguish us from animals. And so, therefore, we don't have a right even to take our own lives, self-murder. So if you go back, you will not find Locke or Mill, I think, justifying suicide or even justifying abortion. So we're dealing with a distinctively modern heresy that removes autonomy from the whole framework of moral understanding. But what you've shown so beautifully here is to remind us that the real leaders, the key voices in the notion of rights for women, and especially the suffragettes and the leaders of this country, were not defenders of abortion. They too understood rights, not in some sort of diminished modern sense, but in a classical view of natural law governing the whole scheme. That they themselves never took my control over my own body as the means, as a ground for removing me from the natural law that would govern us, even in the way we treated ourselves. But otherwise, I think this is quite fine. Just my points of caution.
Yes, I appreciate that. And it's a great honor to have you on. And I do believe the first time you listened to this lecture, you criticized me for the same exact reason. And so um, critique, it's a good critique. And I think what I want to add is just the complication I introduced at the very beginning, that I do think the natural law account very much is not a contrary to this account that I've kind of exposed, but is
Right.
but includes that as well. And I think there are definitely aspects of Locke that you could read as, I mean, as you and I know, having both studied with students of Leo Strauss, there are sorts of debates about how one interprets Locke, whether you interpret him more like a Hobbesian or more like an Aristotelian. So I think there are aspects you can see within Locke that would give way to an older account, more classical account. I think there are aspects you can see that give way to a Hobbesian account. And I think that Hobbes is the real villain here, in terms of if you look in the Leviathan, and if you look in the Leviathan, both in his taking law and right apart, and his really, his coming after by name Aristotle and Cicero and Aquinas, taking law and right apart, taking obligation and freedom apart. And so he really he rips apart this understanding of the two, of law and right, together. And I studied this text because Hobbes out of all is so clear. So the question is, when our women's rights advocates say in the 1970s, and some of them, I actually should look and see if any are actually calling upon Hobbes, but Hobbes himself is making a women's rights argument that is in keeping with the ones we'll see later, because he wants to form the account of equality of human beings, as you know, on this really low basis of the ability to kill one another. And so you can imagine, well, a woman can't really kill a man. Well, if a bunch of women can come together and kill a man. And so it's the ability for us to kind of take our muscle, that kind of low ability to preserve ourselves, that he grounds his rights claims on. And so I very much agree that it's mostly with Hobbes. And then we would have to argue a bit in looking at how Locke has been used, and how I think Mill has been used. I think if you read them themselves, you're going to see absolutely an understanding of the rights as protective of the vulnerable. When it comes to women, it gets much more complicated, though, because women aren't not naturally capable of kind of so think of, and this will be the last thing I say, and I would ask you to go read and I would love to have a discussion private with you about my article in the American Journal of Jurisprudence, where I'm putting John Finnis and my teacher Ernest Fortin together. But I think when it comes to women's rights advocates, what they're doing is kind of taking this frame where, in order to enter into the public sphere, so think about Locke and his liberal man, his Republican citizen enters into the public sphere partly because his wife has taken care of, in the sphere of the private sphere, taken care of all things. So the mistake to be made is that the women, the liberal feminists, are entering into the private sphere, the public sphere, from the private in the same kind of way, by leaving children behind. And I think that becomes, then really kind of grotesque when the leaving children behind is not something like a daycare situation, but also a situation of, affirmatively ending that child's life and thinking it's necessary to do so in order to, make ends meet and that kind of thing. So
And
anyway, lots more to discuss.
right. You're so right, Erica. The real villain is Hobbes, and the critical point, as you so rightly say, of separating natural law from natural rights. And you've made a marvelous case. Thanks so much for what you've done here.
Thank you.
Great. The next question is from Eric Allen. I'll take the liberty of reading it. One of the things that strikes me about the difference between natural law rights and positive law rights is that natural law rights vary depending on the context in which one's duties are embedded, whereas positivistic rights, since they're disembodied from natural communities, are constant and do not vary. Is this a fair way to put it?
So it sounds as though I would not say that's true of positive rights. By positive rights, all I mean are those rights that are determined or specified by, an authority like a legislature or potentially, some sort of, regulation that's allowed. So by positive rights, I don't mean what it sounds like because if you think about it, positive rights, and if you look at good legislation, there are often enunciated duties and rights. I mean, we definitely see this in common law, but when you're good legislation would also sort of like who's the rights bearer and who's needs to carry out the duties for the rights bearer or allow the rights bearer to carry out his own duties. I think that's just spelling out, putting in black letter law what is true in accord with the natural law. What you may be talking about is something more like human rights codes, where you have sort of in black and white or in black code or whatever, you have an enunciation of kind of a high level of generality about what the community has said, and then you might say it's disembodied and constant. Again, I'd probably be going against some of what Hadley Arks talks about, but I think you can fall into more abstraction when you're thinking in kind of like a Kantian way in terms of universality being applied to all things. But I just don't think law works in this way if we're working as we should be at kind of a low level of specificity rather than and this is why if you're a law student, anybody who's out there or a lawyer, that the questions of levels of generality and specificity are really important when we're thinking about those what appear to be more abstract phrases in our Constitution, which if you look at the history, aren't particularly abstract. They meant certain things, but they can tend toward abstraction. And so it's one of the main things that is a problem for us right now, because, I mean, look at, the Vice President Harris on, politically talking about freedom and equality and all these sorts of things, meaning entirely different things from what maybe we might mean, and also potentially what the people who wrote those in the Constitution, equal protection of the laws, or, due process, liberty, those kinds of things. There is some sort of history that allowed for those things to be, and we do need to apply them today. But there has to be sort of the question that Scalia brought to our attention all the time was levels of specificity and generality. And I think those came up with Dobbs and others in the modern court today. So I think those are really important.
We're just going to wrap then with one final question from Ted Hurt. How can the pro-life movement incorporate these natural right principles into a practical advocacy effort for undecided voters at the state or local level?
Yes. So what I would say is that in my discussions with pro-choice advocates, or especially sort of legal scholars, and in classrooms, I was invited to, a reproductive justice classroom at Boston University School of Law. And I think what I mentioned really quickly is that moving from the autonomy framework requires not, in the first instance, talking about the unborn child's rights, not that there aren't any, there are, but but because rights in this way are constantly thought of in terms of autonomy, people in our world today don't understand what you're talking about. And so when you talk about duties of care, so that you just sort of open the discussion of, do you think that mothers and fathers have duties of care to their born children? yes, I do think mothers and fathers, and why would that be? Like, and kind of help them Socratically think about why it is that mothers and fathers owe duties of care to their born children. And then think about, if they talk about, well, biologically, I mean, this is, I would say the argument is that biologically they have brought the child into existence, therefore they are responsible for his or her neediness. And then we ask, well, what about maternal duties of care in when the mother is the only one who can protect and nurture the child? Do you think that there are any duties of care that the mother has during the time when the child is utterly dependent and vulnerable only on the mother? And then I would say, what about, and then bring in the father's duties of care? Because if you talk in this autonomy framework with women, women's rights versus the unborn child's rights, it's hard to get to the father. But if you talk about the maternal duties of care when she's, mother is pregnant, when a woman's pregnant, and then the paternal duties of care, like how does he owe duties of care to this dyad? And then how do we think about society at large, the community, churches, and potentially, the community at large in terms of the state? How do we think about the state providing the conditions under which these duties can be carried out? And other ways in which removing kind of ways in which there are impediments to carrying out those duties, or there are disincentives to carrying out those duties. And I think, thinking in terms of duties of care is something I think is much, because it, is bringing together a legal framework with, I think, a pretty Christian framework that so many people are already active in. Progressives tend to think in terms of responsibilities for the needy, responsibilities, for the vulnerable. You can think of all sorts of occasions in which this is the case. And so like moving into that frame, which is basically a Judeo-Christian frame, I think is a helpful place to start in terms of talking about it. What do I think needs to be done? Lots and lots of good family policy, thinking about how to make the family at the center of, and that for which, other things, communities exist, I think is really important. And obviously the state being hospitable to the family, which I don't think it has been for quite some time.
With that, Erika, I would just like to thank you so much for joining us on our webinar today. And I'm going to turn things over to the Executive Director of the CRCD, Trey Dimsdale, to bring us to a close. Trey?
All right. Thanks again, Erika, for your willingness to share the CLE webinar with us. Once again, it was outstanding. I really enjoyed and appreciated it. Thank you to all of you who have logged on. Please be in touch with us in the coming weeks if you don't get information from us with regard to your CLE credit that you should be receiving either in Virginia or in Texas. I can say the Texas application is pending, so it will be a few days yet, and Thanksgiving may get in the way. But look also for emails from our organizations about other webinars that we'll be doing in the new year and other special programming. But thanks again for joining us today, and I hope to each of you that you have a wonderful Thanksgiving holiday.